In his brief 14-year career, Joseph Smith, founder of the Mormon faith, faced many legal difficulties, but the first occurred years before the word Mormon was ever uttered. In March 1826, the 20-year-old Joseph Smith was arrested and brought before South Bainbridge Justice of the Peace Albert Neely, under the charge of being a disorderly person and an impostor. This event stemmed from his employment as a treasure seer or scryer for Josiah Stowell and others the previous 5 months. Despite the account of an eyewitness and publication of the court transcript, Mormon apologists typically denied the reality of the 1826 trial as an anti-Mormon invention. However, in the summer of 1971, the Reverend Wesley P. Walters uncovered Justice Albert Neely's bill of costs for 1826 in the damp basement of the Chenango County Jail in Norwich, New York. This discovery settled debate surrounding the reality of Joseph Smith's 1826 court hearing and established the authenticity of the published transcript, which is now a major source documenting Joseph Smith's extensive involvement as a treasure seer. The original court transcript is no longer extant, but it was published on 3 separate occasions in 1873, 1883, and 1886. While most Mormon scholars now accept the essential accuracy of the published court transcript, the subject of whether Smith was convicted or acquitted continues to be debated, with apologists defending Joseph Smith's report through Oliver Cowdery that he was honorably acquitted, and critics siding with the concluding statement in the published court transcript, and therefore the court finds the defendant guilty. Indeed, apologists have been far more willing to discuss the fine points of 19th century jurisprudence than the implications of the testimony itself. The most detailed attempt to interpret the trial records in harmony with Joseph Smith's claim that he had been acquitted is Gordon A. Matson's Joseph Smith's 1826 trial, The Legal Setting, in Brigham Young University Studies for spring 1990, which I will critique in my presentation here. While the question of innocence or guilt is less important than the historical information and testimony contained in the court transcript regarding Smith's practices as a treasure seer in southern New York and northern Pennsylvania, this video will survey the relevant documentation and attempt to reconstruct the historical events surrounding Joseph Smith's 1826 legal troubles. Our knowledge of Joseph Smith's 1826 legal trouble is based on the following 6 sources. The first 3 are the contemporary civil records, which are the most important and take priority over later reminiscences. 1. People v. Joseph Smith, Jr., 20th of March, 1826. Trial transcript. Albert Neely docket book. This record includes transcripts of Neely's examination of Joseph Smith, Jr., defense witnesses Josiah Stowell and Jonathan Thompson, prosecution witnesses Horace and Arad Stowell, and a Mr. McMaster, a statement of the court's findings of guilt, and a list of the various fees Neely charged the county. The transcript was torn from Justice Neely's docket book and taken to Utah by Emily Pearsall, Neely's niece, who served as a Methodist missionary among the Mormons beginning in 1870. The original transcript is presently unavailable, but it received 3 independent publications: by Charles Marshall in 1873, by Daniel S. Tuttle in 1883 and in the Utah Christian Advocate in 1886. Analysis of the variant readings among the three versions indicates that each copied from the original court record rather than from one another. Of the three, the Utah Christian Advocate of January 1886 is evidently the most carefully copied. 2. Albert Neely, Bill of Costs, 1826, Clerk of the Board of Supervisors, Chenango County Office Building, Norwich, New York. Discovered by Wesley P. Walters in the summer of 1971, this bill lists Neely's fees for 9 court cases for 1826, Smith's appearing out of chronological order as Case 5. The People versus Joseph Smith, the Glass Looker. While this source records the total cost of $2.68, it does not include the itemization for the various services as does the trial transcript. 3. Philip DeZang, Bill of Costs, 1826, Clerk of the Board of Supervisors, Chenango County Office Building, Norwich, New York. Discovered by Wesley P. Walters in the summer of 1971. This bill includes arresting Constable DeZang's itemization of fees for various services performed in Joseph Smith's case, as well as 7 others. 4. Abram W. Benton, Mormonites, Evangelical Magazine and Gospel Advocate, published in Utica, New York, on 9 April 1831, page 120. Benton, who possibly attended the court proceeding, does not recount the testimony given at the trial, but states that Smith was arrested as a disorderly person, primarily for his activities as a glass looker, and that he was condemned by the court. 5. Oliver Cowdery to W. W. Phelps, October 1835, Letter 8, published in the Latter-day Saints Messenger and Advocate in October 1835, page 201. In this letter, Cowdery admits Smith was brought before a justice in South Bainbridge by some officious person, but claimed that he was honorably acquitted. 6. William D. Purple, Joseph Smith, the originator of Mormonism, Historical Reminiscences of the Town of Afton, published in the Chenango Union at Norwich, New York, on the 3rd of May, 1877, page 3. An eyewitness and trial note-taker, Purple recounted the statement of Joseph Smith, Jr., as well as the testimony of Joseph Smith, Sr., Josiah Stowell, and Jonathan Thompson. According to Purple, Smith was arrested as a vagrant without visible means of livelihood and was ultimately discharged. With incomplete court documents and contradictory accounts, reconstructing the historical event is difficult. Following his discovery of the Neely and DeZang bills, Wesley P. Walters initially argued that the court record and bills represented a formal trial by a 3-justice court of special sessions, but subsequent investigation has virtually ruled out this possibility. If a court of special sessions had been convened, the fact would have been recorded in the dockets of 2 other justices besides Neely. This could not be verified by Walters in 1974 because of the disorganized condition of the county records, but subsequent investigation of the bills of Justices Zachariah Tarbell, Levi Bigelow, and James H. Humphrey by H. Michael Marquardt in May 1988 indicated that a court of special sessions was not held in the Joseph Smith case. The position that quickly gained favor was that Joseph Smith appeared before Neely at an examination or preliminary hearing. Presented with such clear evidence, Walters abandoned his initial position in 1988 in favor of the view that the Pearsall document represented a preliminary hearing. Viewing the court transcript as a record of a preliminary hearing resolved some discrepancies that would otherwise remain inexplicable. Some had questioned the court transcript's authenticity on the grounds that it has Joseph testify first, giving the defense before the prosecution has made its case, as would be expected in a trial record. But Thomas G. Waterman's Justice's Manual of 1825 specifically instructed justices regarding pretrial examinations. After the examination of the accused, all witnesses present are to be examined on oath touching the complaint. Neely's record also reflects the practice of not placing the accused under oath in pretrial hearings as set forth in a new Conductor Generalis, being a summary of the law relative to the duty and office of Justice of the Peace, sheriffs, coroners, constables, jurymen, overseers of the poor, etc. Albany, New York, 1819, page 142. The examination of the prisoner should not be upon oath. There has also been some discussion about the number and identity of the witnesses. The court record names and summarizes the testimony of 5 witnesses: Josiah Stowell, Horace Stowell, A. Red Stowell, A. McMaster, and Jonathan Thompson. William D. Purple, who attended the hearing, recalled in 1877 the testimonies of 3 witnesses: Josiah Stowell, Jonathan Thompson, and Joseph Smith Sr. Apologist Francis W. Kirkham questioned the authenticity of the court record, partly based on the discrepancy between Neely's and Purple's naming of the witnesses. But Purple was not attempting to give a full account of Smith's pretrial hearing, and his addition of Joseph Smith Sr. can be easily explained. Indeed, Neely's itemization documents the presence of 2 additional witnesses, 7 witnesses, 87.5 cents. By law, justices were required to record only testimony relative to the fact or material to prove the offense. One of these unrecorded testimonies may very well have been that of Joseph Smith Sr., as remembered by Purple. The identity of the 7th witness remains unknown. The court record indicates that Smith was arrested and brought before Justice Neely as a result of a warrant issued by Peter G. Bridgman, Josiah Stowell's nephew, who charged Smith with being a disorderly person and an impostor. While impostor is not a criminal offense, as apologist Gordon A. Madsen has noted, it points to a specific section of the New York statute that describes various kinds of offenses under the definition of disorderly persons. The section of the statute applicable to Bridgman's charge states, "All jugglers and all persons pretending to have skill in physiognomy, palmistry, or like crafty science, or pretending to tell fortunes, or to discover where lost goods may be found, shall be deemed and adjudged disorderly persons." This was likely the statute Joseph Knight Sr. referred to when he said, speaking of Smith's 1830 trial in South Bainbridge, that Smith had been arrested for pretending to see underground, and that his prosecutors were motivated by a little clause they found in the York laws against such things. John S. Reed, Smith's legal counsel during his 1830 trials, remembered that Smith had been arrested for the crime of glass-looking and juggling fortune-telling, and so on, which the state of New York was against it and made it a crime, and the crime was a fine and imprisonment. As mentioned, there has been a great deal of discussion about the court record's concluding statement, and therefore the court finds the defendant guilty. For different reasons, Mormon writers Gordon A. Matson and Paul Hindengren have argued that the court's judgment was a later inclusion or an afterthought supplied by whoever subsequently handled the notes. Matson points to the record's consistent reference to Smith as prisoner, except for the judgment where he is called defendant, and Hindengren believes it is inappropriate for pretrial hearings to pronounce judgment. In absence of the original court record, this theory or accusation cannot be verified. However, Neely's use of the term guilty does not necessarily imply a judgment had been reached in Smith's case, only that Neely had found sufficient evidence against Smith to proceed with a formal trial. Regarding pre-trial hearings, the revised statutes of the state of New York for 1829, for instance, instructs, if it shall appear that an offense has been committed, and that there is probable cause to believe the prisoner to be guilty thereof, the magistrate shall bind by recognizance the prosecutor and all the material witnesses against the prisoner to appear and testify at the next court having cognizance of the offense, and in which the prisoner may be indicted. Matson, on the other hand, admits that Neely had authority to pronounce judgment if he desired. The disorderly persons statute previously quoted goes on to instruct the justice of the peace before whom such cases are brought as follows: and it shall and may be lawful for any justice of the peace to commit such disorderly persons, being thereof convicted before him by his own view or by the confession of such offenders, respectively, or by the oath of one or more credible witnesses, to the bridewell or house of correction of such city or town, there to be kept at hard labor for any time not exceeding 60 days, or until the next general sessions of the peace, to be holden in and for the city or county in which such offense shall happen. The last part alludes to the authority of a higher court to review such cases and limit or extend the jail time. Upon review, this court had authority to order such disorderly person to be detained and kept in the said bridewell or house of correction to hard labor for any further time not exceeding 6 months, and during the time of such confinement to be corrected by whipping in such manner and at such times and places as according to the nature of such person's offense they in their discretion shall think fit. In any case, Neely had authority to convict Smith and pronounce a judgment, and there were good reasons to support Neely's finding Smith guilty of disorderly conduct. Indeed, rejecting Smith's defense that he was a real scryer, Neely would have regarded Smith's examination as a confession and his witnesses as material to the offense, given that they gave accounts of Smith's locating buried treasure and lost objects through a seer stone, which Smith even exhibited to the court. Matson believes that New York rulings on fraud, especially the requirement that it must be public rather than private to be criminally indictable, were relevant to Joseph Smith's case. Matson argues, from the array of the other witnesses, there was no testimony that any of them parted with money or other thing of value to Joseph Smith. Only Josiah Stowell did so. In short, only Josiah Stowell had any legal basis to complain, and he was not complaining. Indeed, Justice Neely had no other choice than to discharge Smith. At best, this scenario only tells us how Matson might have defended Smith had he been his attorney. There is no indication that Neely was considering fraud as an aspect of Smith's case, nor does the statute stipulate that such need be the case. In fact, Neely's record of his examination of Smith and the witnesses gives no indication that he was concerned about money changing hands. If Neely had been considering fraud as an aspect of the disorderly person charge, one would expect to find more particularity in the record regarding the exchange of money, especially in recording Josiah Stowell's testimony. Although Smith had testified that he had been employed in looking for mines, but the major part had been employed by said Stowell on his farm, Neely's summary of Stowell's testimony only states that Smith had been employed by him to work on the farm part-time, that he pretended to have skill of telling where hidden treasures in the earth were, by means of looking through a certain stone. Thus, Neely did not confirm Smith's employment as a treasure seer, but rather that he had pretended to find buried treasures through his stone, adding language that reflected the disorderly person statute, although clearly the believing Stowell did not use such language. In fact, pretended appears a total of 6 times, distributed in 4 of the 5 testimonies recorded in the transcript, even in Smith's examination. As mentioned, Smith's defense was that he was a real seer, not a pretended one, and his witnesses, Josiah Stowell and Jonathan Thompson, gave reasons for their belief that Smith possessed a genuine gift. But because New York law made no distinction between fraudulent and real scryers, the court had every right to treat Smith's defense as a confession of guilt and to convict Smith as a disorderly person. However, Neely's itemization at the end of the court transcript and Constable Dzang's bill indicate that Smith's case did not conclude with Neely's verdict of guilty and Smith going to jail, being fined, or escaping. It was more complicated. Indeed, there are other entries and fees that need explaining. Neely's itemization lists the following costs. The first item, warrant, 19 cents, represents Neely's issuing a warrant for Smith's arrest, 19 cents being the standard fee. The second item, complaint upon oath, 25 cents, represents Neely's charge of 25 cents for taking Peter Bridgman's complaint against Smith as a disorderly person. The standard fee was 25 cents. Marshall's 25.5 cents is therefore likely wrong. Item 3. 7 witnesses, 87.5 cents. This is Neely's charge for administering oaths to 7 witnesses at 12.5 cents, as set forth in Waterman's 1825 Justice's Manual. Thus, 87.5 cents for 7 witnesses. To this point, the various interpreters agree, but the meaning of the remaining items is debated. However, the interpretation that fits best and struggles the least to explain the data is that, for some reason, Neely thought Smith's case needed to be heard by a 3-justice court of special sessions. This may have been because of the unusual circumstances of Joseph Smith's case, as indicated by Neely's adding to his bill, the glass looker. It was probably a once-in-a-career case for Neely, and perhaps he thought such an unusual case should be heard by higher authority. Item 4, recognizance, 25 cents, was interpreted by Walters as a reference to Smith's being placed under bond to appear at a 3-justice court of special sessions. Mattson, however, argues that recognizance, 25 cents, refers to Neely's examining the defendant, rather than binding him over for a future trial. However, there was no fee for examinations, only for subpoenas and oaths, and since Smith was not under oath, Neely could not charge the county. Besides, the fee was 12.5 cents as mentioned. On the other hand, the standard justice's fee for bond or recognizance was 25 cents. Thus, Neely was not charging for his examination of Smith, but rather for binding him over for a court of special sessions. Item 5, mittimus, 19 cents. This is Neely's charge for a second arrest warrant, which Mattson passes over in silence. As indicated in Webster's 1828 dictionary, the term usually referred to a precept or command in writing under the hand or hand and seal of a justice of the peace or other proper officer, requiring him to imprison an offender, a warrant of commitment to prison. The usual fee for a mittimus, or commitment for want of bail, or commitment to custody, was 19 cents. Walters initially believed this entry referred to a post-conviction arrest and commitment to prison, but Constable Desang's bill doesn't support that interpretation, as I will soon discuss. Item 6, recognizance, or recognizances, of witnesses 75 cents, was interpreted by Walters as a reference to Neely's putting 3 material witnesses under bonds to appear at the forthcoming court of special sessions. The standard fee for a recognizance was 25 cents, thus 3 witnesses. As with the listing of 2 arrest warrants, the recognizance of 3 witnesses is problematic for Mattson's theory that Neely found Joseph Smith not guilty and discharged him. To escape this evidence, Mattson argues that recognizance or recognize was used interchangeably with examination or examine in the early 1800s, that only the plural recognizances referred to types of bonds or undertakings, or sometimes bail. Mattson's apologetic is highly doubtful for several reasons. Not only is it unclear if the original reading of recognizance in the court record was singular or plural, with the advocate transcription reading singular and Marshall's reading plural, but Mattson's distinction is not supported in the legal documents of the period for Chenango County. Indeed, I have been unable to find a single instance of recognizance used as a synonym for examination in Chenango County records for the decade of the 1820s. Matson's insistence that only recognizances, plural, refers to bail or bond is even inconsistent with New York's revised laws of 1813, which allowed justices of the peace to charge 25 cents for each bond or recognizance. Nevertheless, Matson's interpretation has led him to the erroneous conclusion that only 3 witnesses testified before Neely's court, ignoring completely Neely's itemization of 7 witnesses. Thus, Matson seems confused when he argues. Walters assumes that 3 witnesses were first examined and then put under recognizance to appear later at the supposed second hearing. But as we have noted, if that theory were to be reflected in Justice Neely's bill, there would be a charge for examining the witnesses and a charge for taking their bond to appear at a future time for trial. Only one such charge of 25 cents for the defendant and 75 cents for 3 witnesses is listed. The far safer conclusion, as I maintain, is that recognizance, as used in Neely's bill, means examining defendant and witnesses. Matson apparently also overlooked the fact that Neely's record lists the testimony of 5 witnesses. Having no first-hand experience with the documents in question, Matson does not know that justices in South Bainbridge charged the county 6 cents for an oath and examination of witness, and 25 cents for a recognizance to appear at general sessions. In fact, there was no fee for examinations of witnesses per se, only for subpoenas and oaths. The revised laws of 1813 allowed justices to charge for administering an oath 12.5 cents, and a bond or recognizance 25 cents. Note, there was no fee for examining listed. Note also that at this time there was no separate fee for subpoena, which, as we will see, was subsumed under oath of the witness. When New York statutes were revised in 1827 and 1828, justices' fees were adjusted to include, for administering every oath, 6 cents, and a subpoena for each witness, 6 cents. Note that a bond or recognizance remained at 25 cents. This change is reflected in the Justice of the Peace bills for Chenango County. However, in the People v. Goodwin and Goodwin, 20th of April, 1825, Justice Levi Bigelow was forced to separate charges for subpoenas and oaths because evidently one of the witnesses didn't show. Subpoena for 28 witnesses at 6 cents, totaling $1.68. Swearing and examining 27 of the same at 6 cents, totaling $1.62. In another case, dated 5th of April, 1828, Justice William Banks charged subpoena for witness, 6 cents. Oath and examination of witness, 6 cents. Later, the same month, Justice Banks combined subpoena and oath and charged 12.5 cents for each witness. Subpoena and swearing 2 witnesses on examination, 25 cents. Thus, Neely's itemization of 7 witnesses for 87.5 cents represents charges for 7 subpoenas and 7 oaths, which, when billed jointly, The justices charged 12.5 cents for each witness. From these 7 witnesses, Neely recognized 3 at 25 cents each to testify before a court of special sessions. Item 7. Subpoena, 18 cents. This represents 3 subpoenas at 6 cents each. Since Neely had already charged for 7 subpoenas and 7 oaths, this must refer to his calling the 3 witnesses previously recognized to appear at the Court of Special Sessions. Item 8. Total charges $2.68, which is 1/2 cent less than the total should be, but exactly matches Neely's bill. This is strong evidence supporting the authenticity of the published trial record. Now let's look at Constable Dzang's bill. Item 1. Serving warrant on Joseph Smith and travel, $1.25. This represents Joseph Smith's initial arrest on the 19th of March, 1826. Item 2. Subpoenaing 12 witnesses and travel, $2.50. 12 witnesses is 5 more than what Neely billed for. It's possible that this number includes the 3 material witnesses that Neely recognized to appear at the Court of Special Sessions, and that some witnesses called to Neely's hearing were not examined. Item 3. Attendance with prisoner, 2 days and 1 night, $1.75. Dzang apparently arrested Smith on the 19th of March, held him overnight, and attended the prisoner during the court on the following day. Item 4. Notifying 2 justices, $1. This is perhaps the clearest indication that Neely had found cause to have Smith tried at a 3-justice court of special sessions. Item 5. 10 miles travel with Mittimus to take him, $1. Discussion has centered on the meaning of Dzang's phrase, to take him, in arguing against Walter's earlier interpretation that Dzang took Smith to jail. Matson observes, the phrase to take, then as now, meant to arrest or to capture, hence to take prisoner could more probably mean the act of arresting rather than transporting him somewhere, especially since no somewhere is mentioned. A review of the extant bills from the 1820s generally supports Matson's observation, although the phrase to take does sometimes mean to transport or convey. However, as Matson has argued, it is clear that Smith was not taken to jail, which was about 25 miles to Norwich. If that had been the case, there would have been an additional entry for carrying him to jail. For example, in the case of S.R. Goodrich, the first item on Dzang's bill, Dzang lists carrying him to jail, $3. At this point, one would expect Matson to discuss the fact that there are 2 warrants and 2 arrests listed in Dzang's bill, but he fails entirely to acknowledge this issue. He also passes over the 10 miles travel. However, he does mention Dzang's charge for notifying 2 justices. What is meant of the Dzang entry notifying 2 justices? I frankly do not know. Perhaps Dzang confused this case with the earlier 3-justice court of special sessions, or perhaps Neely first thought the Joseph Smith case needed to be heard by 3 justices and later changed his mind. Well, so much for his interpretation that Neely had found Joseph Smith innocent and discharged him. Matson's first suggestion can be dismissed since there are no misplaced notifying two justices in Dzang's bill. Matson's second suggestion begs the following question. If Neely had called for a court of special sessions, as the evidence seems to indicate, why was not one held? The historical sources suggest a possible answer. Bainbridge resident Abraham W. Benton claimed in 1831 that Smith was condemned, but, considering his youth, he then being a minor, and thinking he might reform his conduct, he was designedly allowed to escape. It is unclear if Benton had attended the 1826 proceeding, but in bringing a warrant against Smith on the same charge in July 1830, Benton demonstrated that he was familiar with issues of the first prosecution. Smith even mentions a young man named Benton, who in 1830 swore out the first warrant against me. The first for 1830, that is, as Joseph Smith's acquittal in South Bainbridge was immediately followed by his arrest and trial in Colesville. This time, Smith escaped conviction since the statute of limitations had run out. In an 1842 statement, Joel K. Noble, the Colesville justice before whom Smith would appear in 1830, also said Smith had been condemned in 1826, but that whisper came to Joe, off, and so he took leg bail, meaning escaped custody. In other words, someone suggested to Smith that he jump bail and leave town. If so, this would explain why a court of special sessions was called but not held in Smith's case. However, Smith's subsequent return to South Bainbridge, first about November 1826, seeking employment with Stowell, and again in January 1827 to be married by Justice Tarbell, suggests that there was more involved than Smith's escaping custody. If Smith had escaped custody, would he have returned to South Bainbridge in such an open fashion? Not likely. I would therefore suggest the following scenario. Because of the unusual nature of Joseph Smith's case, Neely decided to have it heard by a three-justice court of special sessions, and recognized Smith and three material witnesses to appear at the forthcoming trial. Subsequently, Dzang notified two justices and served subpoenas on three witnesses, but Joseph Smith did not show. When Neely learned that Joseph Smith had unlawfully crossed the county line into Colesville, probably from Stowell, presumably to the home of Joseph Knight, Neely issued a mittimus to have Smith taken into custody and brought back to South Bainbridge. Constable Dzang then traveled 10 miles with mittimus to take him. When Smith was returned to South Bainbridge, he changed his plea to guilty, which made the Court of Special Sessions unnecessary, and managed to work out an off-the-record agreement with Neely. Smith had good reason to negotiate, since it was becoming increasingly clear that his defense had no legal basis, and that a formal trial would very likely result in his conviction and possible imprisonment. Smith's youth, being 9 months short of his 21st birthday, may have inclined Neely towards leniency. Besides, although unrepentant, Smith seemed willing to abandon his treasure-seeking career. Smith may have also agreed to leave town for a specific length of time. Had a court of special sessions convened in Smith's case, he could have been imprisoned for up to 6 months. In misdemeanor cases involving non-residents of the county, New York statute stipulated that upon payment of the fine and/or release from prison, the offender shall be immediately ordered or transported out of the said county to his last place of settlement or abode, if known, and if any person so ordered or transported shall remain in said county for 48 hours, or return thereunto within 6 calendar months after such order or transportation, he shall again be fined as aforesaid, or confined as aforesaid. Neely may have insisted that his non-resident defendant leave town for the stipulated time. Thus, when Smith returned to South Bainbridge 8 months later, there was no worry of arrest, so long as he did not engage in scrying. Against this scenario, Mormon apologists prefer to quote W.D. Purple's 1877 statement that as the testimony of Deacon Stowell could not be impeached, the prisoner was discharged and in a few weeks left town. While Purple was an eyewitness, his memory of the event is contradicted by the court record itself, which states that Smith was found guilty, as well as by the earlier reports of Abram W. Benton and Joel K. Noble. Purple was also mistaken about the necessity of impeaching Stowell's testimony. As eager as he was to defend Smith, Stowell actually provided incontrovertible proof that Smith was guilty of disorderly conduct, as New York statute defined it at that time. He was undoubtedly one of the material witnesses bound over to appear at the Court of Special Sessions. More than 50 years after the event, Purple might have only remembered that a Court of Special Sessions had not been held and that Smith had not been jailed or fined. Other residents of South Bainbridge, like Benton, unaware that Smith had been retrieved from Colesville and an off-the-record agreement had been subsequently reached, may have assumed the matter had ended when Smith fled the county. While the documents do not give all the information one would hope for, they hardly support Oliver Cowdery's 1835 claim that Smith had been honorably acquitted. Ultimately, however, conclusions about innocence or guilt are less helpful to the historian than descriptions from friendly witnesses of Smith's early method of operation as a treasure seer. As Dale Morgan concluded, from the point of view of Mormon history, it is immaterial what the finding of the court was on the technical charge of being a disorderly person and an impostor. What is important is the evidence adduced, and its bearing on the life of Joseph Smith before he announced his claim to be a prophet of God.